Good evening. I, Dipanshu Agarwal, a student at the National University of Juridical Sciences and the convener of the NUJS Society for Advancement of Criminal Justice, would take the privilege of welcoming you all to the fourth digital lecture organized by the Society for Advancement of Criminal Justice. Today's lecture is in collaboration with the NUJS School of Criminal Justice and Administration. With us today, we have Dr. Adam Dubin, sir, an assistant professor of law at the Pontificia Comillas University, Madrid, in Spain, where he teaches subjects related to the international human rights law. Dr. Dubin is also an adjunct professor of development studies and comparative US and European human rights at New York University, Madrid. He has also served as a visiting professor of comparative human rights law at several universities, including Nirma University, the NUJS, the University of Strasbourg in France, the University of International Business and Economics in Beijing, Catholic University in Portugal, etc. Dr. Dubin has also undertaken human rights research work in relation to protection of women and children in the countries like India, Kenya, Uganda, Angola, etc. He was recently working with the Angolan Ministry of Justice to train prosecutors and judges on the implementation of the UN Convention on the Rights of the Child. Today, Sir will be speaking on the subject area of rights of LGBTQ community and a comparison between American, Asian, and European jurisprudence. In a country where LGBTQ community is still fighting for the recognition of the rights, it becomes imperative for us to understand more about the community and the rights accorded to them across the world. Through this lecture, the Society for Advancement of Criminal Justice seeks to promote discourse in the field of criminal law after taking international human rights law into consideration. Sir's perspective will definitely help us in understanding the jurisprudence and the evaluation of the rights of the community in much better manner. We are indeed thankful to Sir for taking time out of his busy schedule to deliver this lecture. The moderator for today's session is Professor Dr. Kavita Singh Ma'am, a professor of law at NUJS, who has been associated with the university since the year 2004. Ma'am is an expert on the subjects of criminal laws, criminology, victimology, human rights law, family law, and has many publications and books to her name in this area. Ma'am works closely on laws related to rights of children and women. She has also conducted multiple training courses for various stakeholders of the criminal justice system, including police, prison officials, prosecutors, etc. Ma'am is also the coordinator of the School of Criminal Justice and Administration at the university. We are thankful to you, ma'am, for agreeing to moderate this session. Now, I would like to request Kavita ma'am to please take over the session. Thank you. Since ma'am might be facing some technical issues, sir, I may please request you to please proceed over the topic.
Okay.
It will be very engaging, interactive session. Thank you.
All right. Well, thank you, Dipanshu. Thank you for that introduction. And it's a pleasure to be here with everyone. Particular thanks to Dr. Kavita Singh, who I got to know very well, along with her family, when I spent about 2 weeks in Calcutta at NUJS as a visiting professor. I had a chance to get to know her, members of the other members of the faculty, and it was a real pleasure to spend that time in Calcutta, which is an amazing city and a beautiful city, quite dynamic, and it was really one of my best experiences. I would also say that I had a chance to know many NUJS students. In fact, we here at Comillas, we get NUJS students through an exchange program that we have. And I'll tell you that in the 7 or 8 years that I've been teaching, probably at this point, thousands of students, the best students I've had have come from NUJS. In fact, 2 in particular who are now, I think, just recently finished at Harvard Law School, their LL.Ms. They stand out for me as really some of the best and brightest. But teaching at NUJS was a fantastic experience with outstanding students. Yeah, it was an experience that I will always remember, and I hope to get back to Calcutta sometime soon. So with that said, let me get the presentation up. Let's see. Can you see the presentation? There you go. The only thing is I can't control it. Hold on one second. Let me do it differently. And then 1 second. I think it's easier if I do it from here. Okay, can you see this? Deepshu, can you see this?
Yes, sir. Yes, sir. So
Okay.
it's completely visible.
Yeah, okay, perfect. If it's not, let me know. So what we're going to do today is talk about comparative LGBT rights and jurisprudence, looking at the US, Europe, and then at the very end, I'll briefly touch on India, although we can leave that more for the discussion. I have a lot of slides to get through, so I'll go somewhat quickly, but basically the way I'm going to focus the presentation is I'll start out just very briefly talking about LGBT rights under international law. Looking at where, through the different UN conventions, we see protections for the LGBT community. And then from there, we'll jump into some of the jurisprudence, looking at some of the landmark cases in the United States, Europe, and India. So LGBT rights under international law. We find a whole host of rights under international law that are applicable to the LGBT community. Most prominently under the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights. We have a number of clauses, as we do really in most international covenants, which prohibit discrimination. And if you notice, it says discrimination is prohibited based on race, color, sex, so on and so on, or other status. And the United Nations, through its general comment in the International Covenant on Economic, Social, and Cultural Rights, has clarified that the other status includes sexual orientation. And it tells us that sexual orientation cannot be a barrier to realizing covenant rights, for example, accessing survivor pension benefits, in terms of discrimination, and so on. So it's clear from the United Nations, from the different committees that monitor treaties, that the other status within these non-discrimination clauses extend all the way to sexual orientation and gender identity. In addition to that, we've also had a number of cases, one in particular in 1994, which I'll mention, coming from the Human Rights Committee, in which they said that anti-sodomy laws were an invasion of the right to privacy under the International Covenant on Civil and Political Rights. And the question of right to privacy has come up continuously. We'll see it play out, for example, under the European Court of Human Rights. We'll see it play out, we won't talk about it today, but under the Inter-American system and under many courts where laws that have criminalized sodomy have been ruled to be against human rights based on the right to privacy, which, as we know, extends all the way to the bedroom. Or, as the US Supreme Court said, it extends to the right to be left alone. We also see it in terms of life and security of persons, right? The right, for example, not to be beaten. The right, for instance, not to have your life arbitrarily deprived, and certainly in terms of freedom of expression, right? The right to hold hands, for example, in public between two men or two women, for instance, well, that is expression. The right to kiss your partner on the subway or in public at a rally, well, that the courts have said is a form of expression that is also protected and certainly extends as well to the LGBT community. And then, as I said, we also, under the International Covenant on Civil and Political Rights, they mention, for instance, abolishing the death penalty, and that also links to abolishing the death penalty in cases of same-sex relations. There are a number of countries in Africa, for instance, Sudan, which criminalize homosexuality with the death penalty. And it also, the question of right to liberty, right? The right not to be detained for being LGBT. If we look, for instance, at Uganda, if we look at many countries around the world, Saudi Arabia, for instance, countries in North Africa, we have in the past seen mass detentions at LGBT rallies, underground associations, and so on that advance LGBT rights, which are oftentimes, there is a lack of rights in many countries, and oftentimes many associations which support LGBT causes have to go underground. And a good example of that has been Uganda under President Museveni, who has largely advanced an anti-LGBT agenda, which has led to the criminal prosecution and general persecution of the LGBT community. Nevertheless, even though domestically these laws oftentimes aren't geared towards supporting the rights of LGBT, nevertheless, international human rights, as many of you know, at the end of the day, are what apply, even when states themselves fail to protect the rights of the LGBT community, or at least in theory, human rights apply. So just very quickly, internationally, how have LGBT rights advanced? So I think there are a few things that we can point to. One is that many of the anti-sodomy laws, those were laws that stem from the Victorian era during times of colonialism. Many African countries, for instance, are undergoing reforms to their penal codes, but there are lots of laws still on the books which criminalize sodomy, and that, as a result, has become ingrained in the legal system, and to an extent, even the culture of certain countries. A very sort of anti-gay movement. But nevertheless, I think we can be optimistic that there is a wave towards advancing LGBT rights internationally. By the way, Coca-Cola isn't sponsoring this this talk. It's not product placement. So one thing we can point to is Stonewall, 1969 in Lower Manhattan, which led to the Stonewall riots, and which police entered into a gay and lesbian bar known as Stonewall. If any of you have been to New York City, it's in the Village. And they began beating people, and that led to sort of an international, to an extent, movement advancing the LGBT agenda. And actually, it also marks the time when we now celebrate Gay Pride in many countries around the world. In 1973, the American Psychiatric Association, which is looked to by many medical communities internationally, removed homosexuality as a mental illness. And I would say also that, you know, in the 1980s and 90s, the AIDS epidemic, while it had tragic consequences, at the same time, it helped to humanize, in a way, the face of the LGBT community. Friends and family who were closeted about their sexuality suddenly began falling ill with illnesses. With this illness, and it brought to life that the people we knew, the people that we loved, were actually gay and lesbian, and so that, I think, helped to bring a human face to the LGBT community in many ways, and helped to advance the agenda. And actually, one other point to make is, if you look at a lot of the literature about government responses in the 80s and 90s, one of the things that was pointed out was the failure of governments to act, particularly early on. If we look at, for instance, what Ronald Reagan did, basically it turned a blind eye to it as the pandemic spread across the United States, from New York City to San Francisco. And it wasn't until the epidemic was quite advanced that the government began to take it seriously. So it showed, I think, the level of marginalization that the LGBT community had faced in the United States, but as well in other countries. Tune-in versus Australia, an important case in 1994, which the Human Rights Council, the Human Rights Committee, which is now the Human Rights Council, ruled under the right to privacy that there had to be a repeal of sodomy laws. That was an important message globally, that states had to begin repealing these anti-sodomy laws, many of which, as I said, were Victorian-era laws. And then through there, we have a number of resolutions and so on within the United Nations, pushing forth an LGBT agenda. We begin to see more mainstreaming of LGBT rights and sexual orientation within the UN's policies, their development policies, beginning to collect data, for instance, on LGBT, and begin more high-level discussions on protection. Since then, we've had a number of different General Assembly resolutions dealing largely with extrajudicial summary or arbitrary executions, calling for an end to it, in particular related to the LGBT community. The Human Rights Council as well has also passed a number of resolutions, again, protecting the LGBT community against violence and discrimination, and calling on states to take more domestic measures to end it. We also have the Yogyakarta principles, principles that were signed in Indonesia, which are really soft law, and that is calling for states to take measures to enforce the rights of the LGBT community. In many ways, it mirrors other human rights documents, although this, as it stands at the moment, is not a human rights document. They're principles. We can think of them as guidelines, but they don't have the same binding effect as a UN covenant or treaty. But nevertheless, it may be a march forward towards an eventual the eventual creation of a treaty that might enshrine binding rights for the LGBT community. Similar, for example, if we in terms of how I would envision it, similar to, if any of you know, the Convention on the Elimination of Discrimination Against Women, which is, it doesn't necessarily create new rights, but it calls for states to eliminate direct and indirect discrimination against the against women and girls. In a way, I think that's probably where we may eventually be headed. And this is, I think, a certain juridical foundation for that. It goes without saying that although, as you can see, the international community and many states have advanced significantly in terms of repealing laws that have traditionally decriminalized or historically decriminalized the LGBT community. Nevertheless, there are still a number of states that continue to limit rights for the LGBT community, many of them in Africa, but as you can see, even surrounding India, Pakistan, Bangladesh as well, also have certain limits, Saudi Arabia and the Middle East. So while we have many advances, nevertheless, we're still far from achieving equality amongst the LGBT community. Now, turning to Europe, as you can see, there is, looking from green to red, a fair disparity in terms of protections of the LGBT community. I see this actually as a 2014 map, but it's not too different from if you look at the map now. And not surprisingly, we can see sort of an east-west divide where many communist states, Turkey, for example, which is part of the Council of Europe, Russia, continue to have laws which are strongly anti-LGBT, whereas states, for example, such as Spain, Portugal, that also have higher levels of socioeconomic well-being, those are states and where actually religion has played far less of a role than in other countries. Particularly recently, we've seen increasing support for the LGBT community. Now, under the European Convention on Human Rights, which is the primary human rights document in Europe, and not just for European Union countries, but for Council of Europe countries. So it extends all the way to Turkey and Russia beyond the European Union. We've seen the question of LGBT rights advanced under three primary articles. One is Article 14, Prohibition of Discrimination, which is, well, I'll come back to that in a moment. Article 12 deals with the right to marry, although, again, we'll look at that in a moment. It's complicated. And then most of these cases have come under Article 8, which is respect for private and family life. Just one point, that Article 14 is not a standalone right. So when we talk about Article 14, we always, when we take a case to the European Court of Human Rights in Strasbourg, France, we always deal with it in conjunction with another right. So, for example, Article 14 in conjunction with Article 8. That would mean that somebody is being discriminated against based on their private life. So just sort of keep that in mind in understanding European human rights, that Article 14 is not standalone. We always connect it. For example, if we look at Article 14, Prohibition of Discrimination, and we connect it, for instance, to Article 10 on freedom of expression, if we said, if we limited people's freedom of expression, then it would be an Article 10 issue. But if we said, for instance, Americans in Spain cannot protest, well, then it would be Article 10 in conjunction with 14, right? So just to understand a little bit. So one of the most important cases, which actually paved the way for the 1994 case at the United Nations, is this 1981 case coming out of the United Kingdom, which is called Dubin versus the United Kingdom. And this is a case about laws in Northern Ireland, which made it illegal to engage in homosexual conduct, or what they called gross indecency laws. And what we get in this case is the application of what we call the doctrine of margin of appreciation, something that comes up quite a lot within the European Court of Human Rights. And it's an interesting doctrine, right? And what it basically says is, because they have to bridge the different socio-historical interests of 47 nations in the Council of Europe, the European Court of Human Rights gives a certain margin for states to be able to justify why they may be infringing on someone's rights. And what they say here is that although they understand that Northern Ireland in particular is a strongly Catholic part of the United Kingdom, that that there may be a pressing need to maintain, as you can look here, the moral fabric of society. They say, nevertheless, making it a criminal offense, there really is no sufficient justification for doing that. And they say, although we need to understand and try and balance the rights of Catholics, particularly those who are devout Catholics, nevertheless, the court, within evaluating the margin of appreciation of the United Kingdom, is not able to justify a broad margin of appreciation in allowing morality and religion to, for lack of a better term, trump the individual right to privacy, which is what the petitioners had argued here. So this was an extremely important case, and at the regional and international level set the stage, particularly in Europe, for the repeal of laws which were which criminalized sodomy. So this was an extremely important case. It raised what I think caused a little bit of alarm in going into this case was a 1976 case, a case that predated it, called Handyside versus the United Kingdom, which deals with it's a freedom of expression case, and it has to do with the publication of material that deals with sex, menstruation, and masturbation, and it was aimed at distribution amongst European countries to adolescent communities. And here the United Kingdom objected to its publication. It wasn't pornographic, but it talked about topics. It had some drawings and so on, which some people found to be immoral. And in this case, the court ruled for the United Kingdom. They said, look, it is within the margin of appreciation of the state to determine sort of the spectrum of morality and what information we can give to adolescents and children. And they said that is within the margin of appreciation of the state. So there was some alarm that going into the 1981 case that as well the question of morality would be sort of understood more within the realm of state rights. But actually they broke with it, and they recognized that times had evolved and they could no longer find a justifiable reason for maintaining the prohibition. Now, we have a important case called Schock-Noff versus Austria. There's a little typo, it should be Schock-Noff versus Austria. And this is a case which challenges the question of right, or which seeks to enforce the right to marry under Article 12 and extend it to same-sex couples. And here the court says that this is an Article 8 question. It deals with the right to private and, in particular, family life, that is forming a union between two people. And notice what they say. They say the court cannot but note that there is an emerging European consensus towards legal recognition of same-sex couples. Moreover, this tendency has developed rapidly. Nevertheless, there is not yet a majority of states providing for legal recognition of same-sex couples. The area in question must still therefore be regarded as one of evolving rights with no established consensus, where states must also enjoy a margin of appreciation. So what this case essentially tells us is that the right to marry, the right to same-sex marriage, or the right of people of the same sex to partake in marriage under Article 12 of the European Convention is not a recognized right across Europe. And they say, and again, going back to this map that I showed you before, you can see the wide disparity in terms of recognition of same-sex rights, particularly in terms of same-sex marriage, which is largely clustered amongst Western European countries. And as such, the court says, look, we're going to maintain that margin of appreciation as quite wide because there is such a disparity amongst European countries. We want to try and balance those interests. And as such, states continue to enjoy a margin of appreciation in terms of when to introduce legislative change. So they make it clear that this change in terms of advancing LGBT rights in relation to marriage has to happen organically. That is, it has to happen from the state up and not from the imposition of the European Court of Human Rights. And for many, I think we would argue that was a setback in terms of, considering that in 1981, the court took a very bold approach in decriminalizing or in calling for the decriminalization of sodomy. Nevertheless, they didn't go so far as to do it, as to extend those rights to marry. And actually, here you can see that most questions of gay marriage are clustered in Western Europe. This is just talking about this very briefly, but this for me was one of I think the worst judgments of the European Court of Human Rights. This was a case in 2012 involving France. Before France granted, as you can see here, the right to marry. And actually, sorry, just one thing to mention. In the Schalke-Knopf case, they said that you don't have to provide marriage, but there has to be some sort of legal status. That is important to note. So there has to be some sort of permission for legal unions, something where rights such as pension benefits and right to live together and so on can be recognized or have legally lived together. So they do say that if there's not going to be marriage, there has to be some minimum, which is a legal partnership. So in Gaston Dubois was, as I said, a terribly decided case, in my opinion, and this dealt with the question of adoption. And under French law at the time, adoption by a couple together could only be done if you were married. Yep. So what was the problem here? A woman sought to adopt a child. She was in a same-sex relation, and she wanted her partner to also be able to adopt that child as well, to adopt together. And under the law, only married couples were allowed to adopt together. And they challenged it to the court because they said, look, there is no possibility to actually marry because French law doesn't permit it. And the court basically shrugs it off. If we look at, I think it's paragraph 69, said, next, turning to the second part of the applicant's complaint, the court must examine their situation compared to that of an unmarried heterosexual couple. The latter may, like the applicants, have entered into a civil partnership or may be cohabiting. In essence, the court notes that any couple in a comparable legal situation, therefore, to observe any, by virtue of having entered into a civil partnership, would likewise have their application for a simple adoption order refused. It does not, therefore, observe any difference in treatment based on the applicant's sexual orientation. So they say, look, there is no discrimination, essentially. They say it is true that the applicants also, yeah.
Sorry to interrupt, sir. Can you please make the PPT a little bit bigger because audience is not able to see them.
Bigger.
Full screen.
It is full screen.
Okay, sir.
Yeah, let me just double check. Maybe it's this one is very small. Is it all the slides or just this one?
Yeah, this one, sir. Mainly this one.
Okay, yeah. That's why it's because of how I copied and pasted it.
Okay, sir. Not an issue, sir.
Sorry, just at very last 70 says, it is true that the applicant also alleged indirect discrimination based on the fact that it was impossible for them to marry. However, if we look at 71, in that connection, the court can only refer to its previous findings, basically saying that is that marriage doesn't extend to same-sex couples. So this case for me, it was a case that really manifests clear indirect discrimination, because heterosexuals do have that option to marry, or did have that option to marry, versus homosexuals. But nevertheless, the court doesn't want to deal with it. Essentially, they say, look, this is left up to the states to make this decision. They keep the question of the rights of same-sex couples still within the jurisdiction of the states, pushing for an approach that is largely organic, that is largely state up, and they ignore what I think is a pretty blatant discrimination against the LGBT community. Now, under the 14th Amendment, actually turning to the United States, under the 14th Amendment, cases of LGBT rights have largely been dealt with under Article 14, Due Process and Equal Protection Clause, which apply to the obligations of states, constitutional rights of states. But we also have, and I don't mention it here, the Fifth Amendment, which also is due process and equal protection, but it applies to the federal government. That is, to what extent can the federal government deprive someone of their life, liberty, or property without due process of the law, versus Article 14, which is to what extent can states deprive people of that. So anyway, most of these cases have been dealt with at the state level. So just a very, very quick lesson in US law. When we talk about due process, and I'll talk about this briefly just so you can kind of understand the cases that we look at. When we look at the question of due process, that is, anytime the state is going to deprive someone of life, liberty, or property without due process, the court has developed we can think of as a doctrine, where it divides rights in between fundamental rights and non-fundamental rights. So if a state, for example, is going to deny someone the right to marry, let's say, or the right to procreate, for instance, well, in that case, that is a fundamental right. And as such, the state would have to demonstrate that there is a compelling reason, narrowly tailored, why it's going to limit that right. Versus if something is a non-fundamental right, something which arguably historically is not part of American democracy or American history, then, well, the state only has to demonstrate a rational basis. An example of that, for instance, is the right to smoke on playgrounds. So if someone were to challenge the ban on smoking in New York City playgrounds, for instance, the court would say, well, this is a non-fundamental right, and as such, the government would only have to meet a pretty low level, which is a rational basis, some sort of legitimate reason, in other words. And the court would just have to say, well, it could potentially harm those around them, and that would likely be enough to withstand any challenge to the smoking laws in the United States. So that's how the court understands questions of due process. They divide it into fundamental versus non-fundamental rights, with non-fundamental rights, again, being easier for the state to overcome in terms of its infringement on those rights. And actually, you can see here the analysis. So we also, as well, deal with these questions under equal protection in U.S. Very quickly, the court uses a similar sort of strict scrutiny type of analysis, where it divides it divides groups into categories. So there are certain categories which have more protections. An example of that would be, for instance, race, for instance. Race receive the highest level of equal protection, meaning that if a state is going to infringe their rights, well, they would have to use strict scrutiny. They'd have to show there is a compelling government interest. Whereas, for instance, in other cases, an interesting case that came up a few years ago, this was a teacher in Florida who sued. She had sexual relations with a student, and fascinating case. What she said was that there was a violation of her equal protection laws, of her equal protection rights under the Constitution, because the law in, I think it was it Alabama, said that individuals, adults, can have sexual relations with minors up to 16 years of age, as long as they're not teachers, whereas teachers could not have sexual relations, even if it wasn't your student, with a 16-year-old, whereas a doctor potentially could, or a plumber could. And she won the case, arguing that it was a violation of her equal protection rights. And there, because it didn't fit into the strict scrutiny category, it fell into the lowest category, which was sort of a miscellaneous. Based, in this case, there was a violation of her equal protection based on her profession, and as such, they only applied rational basis to this case, meaning that the state only had to show that there was a legitimate interest in why it created a law saying that teachers couldn't have sexual relations, whereas any other profession could with 16, 17-year-old students. So that's how we understand it. And equal protection, very quickly in the United States, has probably been one of the most important amendments. For example, in 1954, Brown versus the Board of Ed, where the US Supreme Court said that segregating schools violated the equal protection case. Cases, for example, involving, let's take, 1996, whether women could, for instance, join the Virginia Military Institute, a very famous military university or institute in the United States. There they said that there was no reason, justifiable reason, to prevent women from entering the institute. It was a violation of their equal protection clauses. So it's done a tremendous amount, this amendment, to advance the rights of many communities, historically marginalized communities, and continue to be in the United States, amongst them African Americans and women. So, as I said, in the United States, we've seen significant advance on LGBT rights. Again, starting where we saw more attention, with most attention given to it, was in '69 with the Stonewall Uprising, then later the AIDS crisis through the 1980s. And as you can see, if we look at a survey of views of Americans on homosexuality in 1981, 1880, and 84, we see that, again, it's not a huge sample size, but according to the survey, about 62% of Americans said it was never justifiable for two men or two women to engage in sexual relations. And not surprisingly, the jurisprudence of the time mirrors that. And we have a 1986 case called Bowers v. Hardwick. Excuse me one second. And this was a case that was split down the middle with a 5-4 judgment. And it deals with anti-sodomy laws in Georgia. And essentially what was happening at that time was police were coming into the homes. They were breaking down doors of individuals who were coming home from maybe gay nightclubs or bars. They would use some argument of reasonable cause to break down the door. They would say they heard there was a firearm. They got a call of a domestic dispute. And they would find people who were engaging in sexual relations. And with that, they would take them to jail and charge them. And they would become convicted felons under the Georgia statute. And this was not only in Georgia, but this was throughout many states, particularly in the south of the United States. And the case was challenged to the US Supreme Court. And the court said here that, in fact, there is no constitutional right to sodomy. And if we look here, it says the issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy, right? So again, they say, is there some fundamental right? Meaning that if the court is going to violate it, well, if they declare it a fundamental right, then they have to argue that there is strict scrutiny. So the petitioners in this case clearly want the court to deem it a fundamental right. But the court says no. It says it is obvious to us that neither of these formulations would extend a fundamental right. And they go through, if you read the case, they say that there is no right within American history going back in time to find that it has the fundamental nature comparable to expression, religion, and other rights that are oftentimes associated with American notions of liberty and democracy. And in the end, they say it is not a fundamental right. And then they examine it and they say, well, could it potentially be a non-fundamental right? In which case, all they would need to show is that it is a rational basis. And essentially they say, look, even if it is a non-fundamental right, there still is not a rational basis here. If we look at this sentence here, it says, where is it? This is said to be an inadequate rationale to support the law. So what they say here is essentially the petitioners are saying that, that Georgia's argument that morality is a rational basis is not right? That's what the petitioner is saying, is that no, that morality, something being immoral or unacceptable, is not. The petitioner is saying that that's not a rational basis. I mean, that's not a legitimate reason why we should limit people's rights to engage in sodomy, which is linked to questions of privacy, of the bedroom. And the court says that the law, however, is constantly based on notions of morality. And if all laws representing essential moral choices are to be invalidated under the Due Process Clause, the court will be very busy indeed, right? And they say, look, law and morality are inextricably linked. And they say, no, that this is a question that essentially should be left under the jurisdiction of the states. And not surprisingly, this, in many ways, it aligns with, first of all, the European Court's jurisprudence, right, in providing more deference to individual states to determine, organically in a way, the rights of the LGBT community, as it had traditionally done, even, for example, involving African Americans and their rights. But it also goes to the tensions in American society, right, between the rights of the federal government versus the rights of individual states, something that has plagued America from the time of its creation as a nation to the present. I mean, even now with COVID, right, this idea of states need to be able to determine how they want to approach it. So it's a huge tension that has always manifested in American society, and always, and certainly in jurisprudence with judges such as Scalia, Thomas, who have always advocated more for state rights, which may very well be just a cover for a larger anti-LGBT agenda. Nevertheless, we do have a dissent in this case. And they say this case is no more about a fundamental right to engage in homosexual sodomy, as the court purports to declare. And another case in Stanley versus Georgia was about a fundamental right to watch obscene movies, right? And was about a fundamental right to place interstate bets from a telephone booth. Rather, this case is about the most comprehensive of rights and the rights most valued by civilized men, namely the right to be left alone, right? And that is, put differently, the right to privacy, right, which connects to this idea of the right to liberty, right? The right to liberty under the Constitution links to the right to privacy. We get that through a number of different cases that predate this. Nevertheless, the outcome of this case tells us that this right to privacy does not extend to the LGBT community to be let alone. And with that case, as you can see, we continued having quite a number of states which had laws, in some cases that applied to both heterosexuals and homosexuals, although almost certainly they were never applied to heterosexuals. And then many laws which were merely just written or changed to apply only to homosexuals. As America began to change, if we look at a similar survey from 2000, this is from 1999, leading into 2001, 2004, we get about 31% of America begins to recognize, only 31%, that homosexuality is never justifiable. And we begin to see greater support for the LGBT community. And not surprisingly, with that, in 2003 case, Lawrence v. Texas, a case which essentially has the same facts as the Bauer v. Hardwick case. And actually, I would, if you can, I can send this out. I would encourage you to click on this link, which tells a story in quite beautiful terms about Lawrence, about this case. But again, it seeks to challenge it seeks to challenge the 14th Amendment based on, again, the right of homosexuals to engage in intimate sexual relations, right? Again, liberty extending to privacy and privacy extending to intimate relations involving same-sex partners. And in this case, we get Justice Kennedy, who is a Reagan appointee, so somewhat conservative, but in a number of cases has come out in support of LGBT rights. And he says, liberty protects the person from unwarranted government intrusions into a dwelling or other private places. In our tradition, the state is not omnipresent in the home, and there are other spheres of our lives and existence. So he essentially couches this argument in very sort of American terms, which is this notion that government should be out of our lives, right? In fact, the US Constitution is the only constitution in the world written in negative terms, right? The government shall not. So he plays to this idea of clearly limiting the government's role in our home, and he links it to a case from the 1960s called Griswold versus Connecticut, which deals with the question of whether a doctor can prescribe contraceptives, whether a couple can decide whether or not to use them, and so on. And the court says that essentially the bedroom is one's castle, and he builds on that jurisprudence here. And he said, liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. He says this instant case involves liberty. And again, he goes to through a number of cases. As I said, he talks about Griswold. He even links it to questions of Roe in the case of, again, the liberty to choose what one does over one's body. That was a case involving abortion. And ultimately, they rule in this case that there clearly is no rational basis any longer for prohibiting same-sex relations. And as he says here, the case doesn't involve minors, does not involve persons who might be injured or coerced, does not involve public conduct or prostitution, it does not involve whether government must give formal recognition to any relationship, right? And he says, look, we're not talking about marriage, we're just talking about the liberty to engage in it. And he goes on to talk about later on that the state, and this is beautiful language, the state cannot demean their existence or control their destiny by making their private sexual conduct a crime, right? Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. Quoting Casey, it is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. So again, they deal with this case very much couched in this idea of limiting government involvement and the idea of the way that we exercise as Americans our due process right to liberty is by keeping the government as far as possible out of our lives. And as such, the court says that anti-sodomy laws are unconstitutional under the U.S. Constitution. And well, I'm going to jump a little bit. Now, fast forwarding a little bit to another survey, which looks at 2010, 2014. And again, we continue to see a decrease in whether or not Americans view homosexuality as being justifiable. And as you can see, the numbers continue to decrease and always justifiable. That is, there's always a reason why homosexuals can engage in same-sex relations increases. And with that, we get the Oberfell versus Hodge case in 2015, which deals with the question of whether whether the fundamental right to marry under the U.S. Constitution within the idea of liberty extends to same-sex couples. And I guess you can probably predict the outcome judging by the White House. I have no doubt that if this case were decided now, the flag would not be projected onto the White House. But that was at a time when we had a very decent human being in the White House, unlike, as I'm sure many of you would agree, this awful president that we have now. But anyway, I'm not going to get myself wrapped up in that now. So again, the question here is, does the 14th Amendment extend the right of homosexuals to marry? And what's interesting about this case, and I just want to pull up, because I didn't bring it, one particular sentence, but what's interesting about this case is they don't deal with the right to gay marriage, right? Because keep in mind, if the court were to deal with this question as a right to gay marriage, a right to same-sex marriage, then it wouldn't be a fundamental right, right? It would be a non-fundamental right, and as such, and as such, the government would only have to demonstrate a rational basis for limiting or for not recognizing the right to gay marriage or same-sex marriage. So instead, what the petitioners argue here is that there is a fundamental right to marry, and that homosexuals should have the right to partake in that fundamental right. And if they're not going to allow it, then they have to, the state has to defend based on strict scrutiny, right? That there has to be a compelling government reason why the state is not allowing it. So it takes it to a much higher level. And ultimately, and I would encourage you to read the case of Oberfell versus Hodges, where you can find it online. I'm just looking now in my course booklet for a beautiful sentence that I wanted to read you. I should have marked it before here. Anyway, it goes through the importance of marriage, and it's a tremendous, really, history lesson in marriage and the evolution of marriage within the world, but also in the United States. And they say, look, I mean, marriage was originally between a white man and a white woman. We didn't even extend it to blacks. Then later in the 1960s, we have Loving versus Virginia, which sort of reconceptualizes marriage under the Constitution and says actually biracial marriage is permitted. So they say marriage is not something that just is kind of a sort of static figure, but that it evolves as society evolves over time. And they talk about, in this case, the importance of marriage. And there's a beautiful line in here where they say, rising from the most basic human needs, marriage is essential to our most profound hopes and aspirations, is what they say, that it is part of the fulfillment. It helps people to find meanings in their secular realm. Its dynamic allows two people to find a life that could not be found alone, for a marriage becomes greater than just the two persons. The lifelong union of a man and a woman always has promised nobility and dignity to all persons without regard to their station in life. And they say marriage is about calling out at night that you need help and having someone there who will answer you. I mean, it's tremendous, tremendous language that the U.S. Supreme Court oftentimes writes in its judgments. And I would encourage you to read it. In any case, I want to just point out the last paragraph of this. It says, no union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law, and the Constitution grants them that right. Beautiful, beautiful language. And with that, the court says that the 14th Amendment right extends to, or the 14th Amendment right to liberty includes marriage, and the right to marriage also encompasses same-sex couples. And as such, from that point on in 2015, throughout all the United States, same-sex couples have the right to marriage. I mean, it's a beautiful, beautiful case, and I would strongly encourage you to read it. And as you can see now, same-sex partners are protected both in terms of equal protection and the due process right to liberty. Just very briefly, I want to talk about a few other cases. This was a case that just came out a few months ago, a month or so ago, in June, Bostock versus Clayton, and this deals with the 1964 Civil Rights Act, which prohibits against employment discrimination based on race, religion, and sex. And so the question here is, can an individual be fired based on their sexual orientation? Well, the government, supported by the Trump administration, said that yes, they can, that the term sex applies not to sexual orientation, but it applies to whether you are a man or a woman, and that sexual orientation, looking at this Civil Rights Act in purely textual terms, isn't included, and as such, there should be employers should be permitted to discriminate, is essentially what they say, and it should be left up to the states how they want to legislate. Again, giving more power to the states in this question. So in this case, we have a judgment which actually says that sex links to questions of sexual orientation. And this case was actually, the deciding vote was made by Justice Chief Roberts, Justice Roberts, who was a Bush appointee, so a conservative judge. But nevertheless, what is arguably almost funny about this case is he says, actually, we are engaging in a very textual reading of this case, because what he essentially says is, look, if you are a woman, for example, and you are married to another woman, and, well, we decide to dismiss you, well, we are actually discriminating based on your sex, because if you were a man who was married to a woman, well, then there would be no issue. So they say that, in fact, this 1964 Civil Rights Act does extend to sexual orientation, because someone is being fired based on their sexuality, who they love, or who they are, or their sexual orientation. And as such, if they were not a man or a woman, well, then they would be heterosexual. And as such, there would be no reason to fire them, is essentially what they say. So it's a case that looks at it, arguably, in textual terms, but arguably it does also take sort of an expanded meaning to it. Now, anyway, this I'm not going to, for the sake of time, I'm not going to go through it. But what's interesting here is the dissent in this case. Where is it? They say the court tries to convince readers that it is merely enforcing the terms of the statute, but that is preposterous, right? This is what the right bench of the court says, a much more textualist reading. They say, even as understood today, the concept of discrimination because of sex is different from discrimination because of sexual orientation or gender identity. And in any event, our duty is to interpret statutory terms to mean what they were conveyed to reasonable people at the time, right? So clearly, sort of a very sort of originalist doctrine the court is advancing here. If every single American, well, anyway, and then look, this is the best line. They say the court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation championed by our late colleague, Justice Scalia, but no one should be fooled. So they say here, this is essentially bullshit, is what they're saying here. So they look, this side of the court is trying to make this argument that they are taking a textualist reading to this, but look, we are the real textualists. Those of us on the right, former Justice Scalia, Thomas, Alito, we are the ones in this sort of textualist school of statutory interpretation, and what you are doing is trying to pass something off. But ultimately, the court in this case found that indeed, by a 5-4 vote, that the 1964 Civil Rights Act does extend to protections of employees based on their sexual orientation. But again, what's interesting about that is how they interpret it, right? That this idea of sex determines, well, your orientation, your sexual orientation, and as such, that is a prohibited area under the 1964 Civil Rights Act. And then one final case in the U.S., which some of you probably know, the 2018 Colorado cake baker case, where a cake baker who owned a store in Denver known as Masterpiece, it's called Masterpiece Cake, as he said, he is making cake pieces to his master, who is God, does not allow him to make wedding cakes for the LGBT community. This was an interesting, for same-sex couples marrying, and this was an interesting case because it balances religious rights and also the right to freedom of expression as an artist, a cake artist, with the rights of the LGBT community. And ultimately, this case rules in very sort of isolated terms. They rule for the baker, saying that the Colorado Board of Human Rights demonstrated animosity to this individual based on his religious preferences. And as such, and you can see this by the 7-2 ruling, that most of the court agreed that this was a case more based on animosity to this individual and religion. And as such, his rights took priority over those of those who were potentially discriminated against. Nevertheless, the way this case is written were in very narrow terms, saying that this case only applied to this situation, and it does not open the door for restaurants and stores to begin discriminating against the LGBT community. That is something that still is up in the air. Okay. Lastly, transgender rights. Europe has provided more protections for the transgendered community. The U.S. has taken a much more state by state approach. President Obama did allow, for example, passports to reflect current gender if accompanied by a doctor's note. The Bostock case extended also to transgender persons as well. The transgender ban in the military under Trump, that was a step back. But Europe, on the other hand, has extended more protections. For example, the European Court of Human Rights in a 1992 case, going back quite far, B versus France, said that a failure to recognize a completed gender reassignment surgery constituted a violation of Article 8, right to private life, when someone's insurance plan failed to pay for their gender reassignment surgery. In Schlump versus Switzerland, again, the court ruled that that was a violation of their right to private life. And a 2000 case, Goodwin versus the UK, the European court as well said that a denial to amend a birth certificate in terms of someone's gender was also a violation of their Article 8 rights. So we've seen much more protections coming out of the European court than we've seen coming from the United States Supreme Court, which has taken, again, a much more state-by-state approach in advancing those rights. I've put up some hyperlinks here where you can see some of the differences in terms of how European countries have advanced or not transgender rights. And you can also get some more information if you click on this hyperlink. And here you can get a map of transgender rights, seeing that many states, perhaps particularly those in the South, provide many fewer protections to transgender people than, for instance, New England and the West Coast, which are traditionally more progressive in terms of advancing an LGBT agenda. It's the South, as you probably saw from the previous slides, which were the ones that had a state-by-state approach, a very state-by-state approach to anti-sodomy laws. And I'll end with this last case, and I'm just going to say a few words about it. This is the 2018 case of Najtez Singer Johar versus Union of India, an extremely important case, which arguably reflects within India a growing acceptance of homosexuals. And with this case, and this is the only slide, there is a challenge to Section 377 of the Criminal Code, which sought to repeal the ruling, overrule the ruling in the previous Suresh judgment, where the court makes an interesting argument in the Suresh judgment, arguing that a minuscule fraction of the country's population constitute lesbians, gays, bisexuals, or transgender, and as such, there is no reason, essentially, to strike down Section 377, which the government of India, in its response to Suresh, said that this is not a sustainable basis to deny the right to privacy, right? It was, frankly, a terrible argument, this idea, well, it's a small percentage of our population, and as such, it does not extend. They also deal with it based on morality. But finally, in the Navtej judgment, the court overrules Suresh. And I'm sure many of you have seen the case, so I'm not going to go through it. But what I thought was, Indian judgments are oftentimes amazingly complete. U.S. judgments are beautifully written, and they can be read as practically novels or historical documents, but Indian judgments, and I think this is a great example of it, does an amazing job, the court does an amazing job of pulling together arguments that draw on philosophy, on modes of interpretation, on international law and cases. And what you see in this judgment is how all of the cases that we've looked at, starting with Dudagin, but also under international law, the Tunin case, but Griswold, Bowers, Lawrence, Oberfeld, the South African cases, Israeli cases, Fiji cases, the European Convention, CEDAW, the International Covenant on Civil and Political Rights, economic, social, and cultural rights, all of that forms the basis of the judgment. So what we can see is, particularly in a common law tradition, the importance of creating jurisprudence, right? This idea of creating precedent. And I think what this case shows also is the power of customary law, because the court essentially recognizes the rights or the right of privacy extending to same-sex couples as within the customary nature of law. And the way that it demonstrates that opinio juris and that state practice is by citing a wealth of international jurisprudence, international law, regional conventions as well. And it goes so far as to defend its arguments based on this idea of the Constitution of India being a living document. This idea of, as they say, of theory of progress, right? This idea that if we are to be a society that progresses, well, we have to go not only in terms of customary law principles, but also in terms of understanding and interpreting our Constitution as a living document. And finally, he pulls the Indian Supreme Court pulls off a philosophy. Rawls' conceptions of dignity, autonomy, and self-determination, the arguments of textualism versus progress, they even link to questions of Shakespeare and human dignity. So it's a judgment that is, while perhaps not beautifully written because it is somewhat formulaic in its writing, nevertheless, I think serves as a model. Both for, I think, the Indian courts in terms of the precedent that it gives, but also for the world community and the importance of looking at what other states are doing in terms of crystallizing certain rights as within the realm of customary law, and the importance of any government, of any court, whether it be the U.S. court or of the Indian court, of taking into account international human rights courts. The U.S. Supreme Court in particular is very quick to sort of poo-poo international human rights law, whereas the Indian court, I would argue, does a better case of doing. Another example is some years ago, the Laxmi Devi case that deals with the right of maternal health in India. And once again, I think the court in that case does a wonderful judgment of recognizing, CEDAW, the right to health under the International Covenant on Economic, Social, and Cultural Rights, cases in Europe, and so on. So again, this is just another example of, I think, the Indian court doing what it should be doing, and that is looking at how society is progressing, taking a more progressive over textualist approach, and following its obligations under international law to look at customary and treaty law in its judgment. So with that, I say thank you to all of you. Rather than sort of giving some broad conclusions, I think I'll open it up for discussion, debate, and thank you to all of you who are listening. I probably went way over time, but anyway, sorry about that. Can you hear me?
Yes. Thank you, Adam, for enlightening us on the issue of LGBT rights. And you gave a comparative analysis of US, UK, and towards the end, the Indian context. I'll not take much time. The first question is from Saif Rasul Khan. Saif Rasul Khan. He has actually two questions, but I'll put you one by one. The first one is, in India, the current surrogacy bill explicitly excludes LGBT, and it will ban commercial surrogacy. So does it violate reproductive rights, and what can be done to address that? Yeah,
so it's a good question. So the question of surrogacy is still sort of an evolving area of international law. A number of UN officials have called for caution in terms of how states legislate on it. In fact, we can look to the optional protocol of the Convention on the Rights of the Child, which deals with the question of the sale of children, pornography, child pornography, and so on. And that is how the UN and international community has looked or is looking at the question of surrogacy and the potential implications of it. But I would argue that if there is a surrogacy bill that has been passed in India, then it would have to extend to the LGBT community. I think it's quite clear under the Universal Declaration of Human Rights, International Covenant, Civil and Political Rights, and really every treaty, as we saw, that the other status applies to the LGBT community. So I think there's a clear opportunity to say, yeah, that the exclusion of LGBT in a law violates equal protection and non-discrimination under international law. So I would argue that it is. Nevertheless, again, the question of, and I'm not familiar with the surrogacy bill in India, nevertheless, you'd have to look at it in the context of how questions of surrogacy are evolving under international law. And I will say I'm not an expert in surrogacy rights, but that's how I would interpret that. If there is a law, then it would have to extend to LGBT.
Thank you, Adam. I would like to add to this is that, the commercial surrogacy is banned in that bill, and LGBT community has also been excluded. What it is actually that, there has to be proper safeguards to see that these children are not trafficked later on. So, keeping a track of these children, whereabouts, well-being, welfare, best interest of the child, there has to be proper procedure laid down there within the law, and by adding these safeguards, I think we could actually include the LGBT community within it.
Yeah, absolutely. Yeah, I mean, there is no prohibition, right, on surrogacy internationally. It's something that's left up to the state. But as you say, I mean, nevertheless, there have to be safeguards, and they have to conform to the convention, in particular, the Convention on the Rights of the Child, the right to best interest, and then the optional protocol dealing with the sale of children, right, in terms of sort of the non-commercialization of it. So I think that is absolutely right, and states can legislate based on those guidelines, but the problem becomes when you exclude a group like the LGBT community, and I would argue that that is a violation under international law, under, again, the non-discrimination and equality of laws statutes within the international treaties.
We also have another question from him only, Saiful Rasul Khan. That is, do you think that the United Nations should take more proactive steps to make separate convention for affirmative protection of LGBT in the light of principles of Yoga Karta?
Yeah. Absolutely. I mean, I think that that the United Nations has increasingly come out stronger on LGBT rights. In fact, even internally, they've extended, for instance, pensions to same-sex partners and so on. Nevertheless, they have been sort of lukewarm in terms of advancing a covenant for more affirmative protections of LGBT, particularly, and in relation to direct and indirect discrimination, similar to what we see in the CEDAW Treaty. But at the end of the day, I think the United Nations is balancing certain interests, and a lot of that, the pushback is coming from African countries, from Arab bloc countries, traditionally from Latin American countries as well, which are quite conservative, based on Catholic values, although that has been changing. And even the Inter-American Court on Human Rights has taken a more progressive approach. And we can't forget that the United States has, under Trump, pushed back against LGBT rights at the United Nations. So I certainly think they should. But again, it's an organization that tries to balance the interests of over 100 and however many, 80 or 90 states around the world. And when you have big blocs such as Africa, the Middle East, parts of Asia as well, that have come out against LGBT rights, and not to mention the lobbies of Christian groups and so on, it is a difficult act. So I think we are slowly moving in that eventual direction. Again, we've seen from the Human Rights Council, we've seen from individual committees, CEDAW Committee, CAT Committee, Convention Against Torture, and so on. We have seen greater recognition of it. But certainly it hasn't, I think, been as strong as it should. And I think what it needs to do is ultimately create a convention. And I think that's true even if we look, for instance, at the African court system, at the African Court of Human Rights, the African Commission on Human Rights. I think there as well, that there needs to be greater protection. So it's not only at the international level, but I think regional courts as well, or regional human rights systems, the Inter-American system, the African court system as well, in particular, which has been terrible, the African Union, which has been terrible on gay rights. I think it also needs to start more at the regional level as well. But absolutely, I think we're eventually heading in that direction, but it's going to be a slow march forward.
Okay, thank you. So we have from our convener, Dipanshu Agarwal, one question, that is, how much the role does religious belief in Europe plays as far as acceptability of homosexuals is concerned? And he also has another part of the question, that is, what has been the position of relatively advanced Scandinavian countries?
Yeah. So religion does play a role in it. I mean, I think, for example, if you look at a country like Poland, Poland has been terrible on LGBT rights. Countries like Serbia, for instance, Montenegro, a number of Eastern European bloc countries that are strongly Christian have advanced a strongly LGBT community. In fact, even, I mean, the growth of nationalism, right? Nationalism, xenophobia, and so on, has in many ways, it is linked to questions of Christianity and Catholicism. I mean, here in Spain, for instance, we have the rise of a far-right party called Vox. I mean, a terrible, terrible party by my standards that has pushed for a greater Spanish nationalism. And within that nationalism is religion. And within that is has been, I would argue, an attack on the LGBT community. In fact, much of it is guided by these sort of traditional notions of masculinity, right? Masculinity also connected to the traditional role of the Christian male. And for example, here in Spain, Vox has pushed for the gay rights celebration to be put inside a park as opposed to down the main boulevard. So that they've come out and they've made a number of statements which have been largely anti-gay. And again, what they are doing is appealing to a historically Catholic traditional population here in Spain. I will say that Spain was one of the first countries to legalize gay marriage, and that was under a socialist government, probably about 15 years ago or more, and that came partly off of the heels of 40 years of Franco, who was the dictator, and there was sort of this rebellion against certain Catholic Christian values, and I think that's partly what gave way to such an early support for LGBT rights here in Spain. But nevertheless, we are again, as many countries are going through in Europe, going through a nationalistic wave that has been largely connected to notions of traditional Christianity and Catholicism, and that has in turn, I think, led to greater attacks against LGBT rights. Nevertheless, yeah, in Scandinavia, where religion, I don't know that much about Scandinavian countries, but there has been greater support for the LGBT community traditionally in countries like Sweden, Norway, and so on. But in general, I would say that it also mirrors a greater support for socioeconomic well-being, and that the advancement of LGBT rights has been linked, I think, I would argue, to a much more advanced understanding of human rights, and this idea of tolerance, this idea of tolerance, socioeconomic justice as a greater social welfare state. So I think in many ways, again, what has guided largely the principles of Nordic countries has been a firm belief. I mean, look at, for instance, the Nobel Peace Prize, right, in the Nordic, in Norway. No, so yeah, I would argue that that the Nordic countries have traditionally been much stronger on LGBT rights than other countries that have been more steeped in religion, particularly in Southern Europe. And
I would completely agree with you, Adam, on this point, because when we look into the Indian jurisprudence and see that the same-sex relationship or LGBT rights violated did not find or they were not criminalized. I mean, before the Indian Penal Code coming in place. So when Macaulay sat down and had written the criminal law for the Indians, then he imported the idea from the English law into the Indian context. And since then, Section 377 finds place in the Indian criminal law. So prior to that, in the history, you will not find that these community people were actually criminalized. Rather, they had got very good positions in the courts of the kings, starting from the very beginning. If we talk about the Hindu kings or the Muslim kings or the Mughals in various times. Only during the English British period, we find that this came into the criminal law. Okay, taking from there, we have another question from
Professor Kavita. Just building off of that, I think it's interesting that you make that reflection, because if we look at, for instance, Africa, right? Africa, if you go to oral histories, that have been passed on, drawings, for instance, I mean, there's evidence, right, that homosexuality existed and was tolerated. Nevertheless, I mean, many of these laws, these anti-sodomy laws, almost, well, all of them really, were brought on during British and French colonialism. And in fact, Christianity was brought on to the continent of Africa through missionary schools, which sought to pacify during after the Berlin Act, in which they formalized the colonization of Africa. And it was brought on in many ways to sort of pacify the African population, create structures and morality. And most recently, what has happened in Africa has been that the religious right, interestingly, in the United States, Southern evangelical groups have begun funding many African leaders now to enforce anti-sodomy laws. And African leaders like President Museveni, for instance, in Uganda, rather than coming out and saying we're taking money to pass laws from evangelical groups, they're actually linking it to questions of nationalism. And what they're saying is, homosexuality is a European idea. It's a U.S. idea. President Obama, keep your notions of sexuality outside of our country. And they're saying that Africans don't tolerate homosexuality. So they're linking it to this idea of sort of Pan-Africanism and nationalism. And that has largely, by much of the population, gained support, when really, it's something that has historically linked to it. So politicians have really taken advantage of these sort of nationalistic Pan-African waves to support to advance an anti-right agenda. But really, what's below it is a lot of money by evangelical groups that have.
Yes. In India also, the players in different ministries and governments have a very great role to play in pushing or pulling back the laws. That means that they want to bring in or they don't want to bring in, depends on the push and the pull factor always. Yeah. So I will not take much time. We'll go to the next question. The next question is that the dissonance that exists between Ishita Das, the dissonance and that exists between the federal state and the state government. Do you think it is easier to engage in anti-LGBT behavior, especially when judiciary fails to check the same?
Yeah, so let me just think about that for a moment. You're talking about in the U.S.?
Yes, U.S. federal and state government.
Yeah, absolutely. I mean, I think it comes down to a very ideological divide, as I said, that has traditionally, in my opinion, plagued America, right? Which is this question of state versus federal rights, and similar to the European Court of Human Rights, which gives this fairly wide margin of appreciation on LGBT rights. The U.S. Supreme Court is essentially doing the same as it did on the rights of blacks, as it did on the rights of on abortion rights, right, prior to Roe versus Wade, and later Planned Parenthood versus Casey in the 1991 judgment. It says, look, states have these rights. So I think on questions that are somewhat polemic, on questions that create a real social divide, oftentimes along religious lines, the Supreme Court oftentimes gives greater deference to the individual states to sort of grow their rights based organically, right, as opposed to sort of interpreting it within the realm of the U.S. Constitution. And inevitably, it does make it much easier to engage in anti-LGBT behavior when there's not federal protections. What we can see now from the Cake case, right, to up until very recently, the Bostock case, is that, yes, states have failed to protect the rights of the LGBT population. When there's no federal legislation which actually protects it, then absolutely it leaves a pretty wide open door to discrimination. And the LGBT community has traditionally suffered tremendously in the United States, and it continues to. Although there has been through Oberfell, Lawrence before that, the Bostock case. Nevertheless, there is still a tremendous margin to discriminate against it. Oftentimes, there's anti-gay violence. Nevertheless, the federal system doesn't get involved in treating it as a hate crime. So, absolutely, I would be in support of seeking more federal power to prevent anti-LGBT behavior. But the United States is where it's always been, in this tension versus state by federal rights. And until the federal government is empowered to pass legislation, has the support within Congress to support it, we're going to be in the same in the same situation where groups such as LGBT, women as well, in terms of abortion rights and so on, continue to some extent be left up to the whim of individual states to make the decision of what is and isn't acceptable. And now, certainly with the Trump administration, who has taken a terrible attack on gays and lesbians, who has eliminated transgender people from the military, who has seek to withdraw a number of protections against LGBT community, we're absolutely in a worse place in some ways than we were under the Obama administration.
Okay, so we come down to the next question. This is a big question by Shreya Mishra. That do you think that decriminalization of homosexual in any jurisdiction merely gives recognition of individuality, but equal opportunity to advance and develop their human potentials, and social, economic, and legal interest remains strained?
Sure. I mean, if I understand it correctly, so, it is about individual dignity, right? I mean, if we look at the jurisprudence of Lawrence, I mean, they talk about that quite explicitly, that that privacy is about dignity, right? It's the right to be left alone. It's the right to be able to engage in sexual relations without the state involving itself. It's the right of not being labeled as a criminal and all of the repercussions that it has, from not being able to get jobs to a general stigmatization of being a criminal. So absolutely, I mean, it is about individual rights under law. The same thing in India, right? It's about the individual right to engage in sexual behavior. I mean, it's not. It's perhaps arguably not sort of within the collective rights or the collection of collective rights, as it is more in sort of individual right, a civil and political right, and the right to privacy. But going to your second part, do these other interests remain strained? And the answer is yes. I mean, when we're talking about something like LGBT rights, when we're talking about something like African American rights, racial advancement, we're talking about women's rights, the reach of constitutional court cases, the reach of human rights law, the reach of constitutions only goes so far, that at the end of the day, what we're always up against is a country's culture. And the Navtej case will only change so much. I mean, if you go into rural India, will you see a difference if you're in Delhi? Will it, you go to the United States, for example, and there is still a strong anti-gay sentiment. Will employers, following the Bostock case, still look for reasons to dismiss people based on their sexual orientation? And the answer is absolutely. So, a lot of it is sensitization, and the courts can only go so far. For example, when we teach in Angola, for instance, on the Convention on the Rights of the Child, the rights of the child are there, right? The rights of the child to have access to justice, to be able to get a fair case when there are instances of sexual violence against that young girl are certainly there under the Convention on the Rights of the Child and the Optional Protocol. But nevertheless, when a machista sort of mentality is ingrained in a society, well, inevitably the rights of girls and women are less protected, even though the constitutional protections are there as well. And the same is true with LGBT, that although in theory there should be equal opportunity, nevertheless there are cultural limitations to how far those constitutional judgments can really go in effectuating change. And it's going to take generations before those constitutional judgments really begin to filter to a much more widespread demographic in a society.
and LGBT community gets benefits out of it, right? So we come down to the next, yes,
Yeah.
next question. We have too many questions. And so we have Pratyush Jana. His question is, there have been demands for introduction of anti-discriminatory laws to help the people from LGBTQ communities gain access various necessities. What is the scope of such policy measures? And he adds to it, what effective measures we as a young lawyer should take to enhance the representation of the
See. So, okay.
What is the scope of such policy measures?
Okay. Was that? Can you put on the question from before just so I can read it? Okay. That looks like the Bollywood character from Three Idiots. No, if I'm not mistaken. No, is that what's, I forget his name? Khan. No. Okay. Anyway. So let's see. There have been demands for the introduction of discriminatory laws to help people from the LGBT community gain access to various necessities like job, healthcare, education, etc. So, what was the second part of the question?
That what as a young lawyer they can contribute in and the policy matters.
Yeah. So, as a young lawyer, I mean, I think there are a few things. I mean, I think one is, regardless of whether you work for a big firm like, what is the great Indian firm, AZ Lawyers?
Oh, sorry, Adam, I have mixed up that question with another student's question.
Okay.
Pratyush Jana's another question is, has there been any demand for this? Okay, same question he has typed here, but previous one is, what is the scope of such policy matter?
Yeah, so I think there's a few things. I mean, I think, the scope of policy measures has to encompass a few things. One is, there has to be a clear definition of sexual orientation within anti-discrimination laws. That is, it can't be left open in the other category, as it is, for example, in the UN treaties, although it's been interpreted by the committees to apply to gender identity and to sexual orientation. So I think there has to be an explicit recognition, right? For example, in the 1964 Civil Rights Bill, it says sex, but this whole case was about whether or not it implies sexual orientation or not. So I think there has to be clear, explicit language that sexual orientation is included in these laws. It also has to clarify that such laws apply both to public and private sectors, right? That it's not only about non-discrimination in the involvement of government, government jobs and so on, but that it also applies to the private sector as well, which is what a number of federal legislation, for instance, in the United States, does in relation to women, to religion, and so on. So I think those three elements are important in drafting an anti-discrimination law, and not making sure that it's not left open to interpretation. In terms of what is the viability of such policy measures in India, that you would know better than I would, Professor Kavita. I mean, my understanding is that probably in more cosmopolitan areas like Delhi, Mumbai, perhaps Calcutta, you might find more support for it, but that certainly in inland, and India still remains a highly rural traditional society, there would be significant pushback against such laws. And I don't know that the current BJP party, that Modi leads, would necessarily know, which again, I'm just making an assumption here, it would probably not be in support, that it still continues to toe a fairly conservative line with respect to LGBT rights.
Right. I will not comment on this. Later on, we may have discussion on it separately. We have Simran Upadhyay's question, where she is asking that what effective measures we as young lawyers should take to enhance the representation of the LGBTQ rights, which brings the rapid legislation in India or across the world.
So we should take to enhance LGBT rights, which will bring in rapid legislation in India or across the world. So, it's a good question. Where to start? So I think as young lawyers, regardless of whether you work for an NGO or for a big Indian firm like, what is it called, ATZ Lawyers, I forget the big firm in Delhi, but these big prominent law firms, it's important to always I think, take pro bono cases. That is, just because you're making lots of money as a corporate lawyer, don't forget that people need your help. And if you're there as a corporate lawyer, as a NGO lawyer, and particularly, all of you who have gone through NUJS, I mean, you are sort of the best minds, the best legal minds of India. You've been trained by people like Dr. Kavita Singh, for example, and as I've said, the students from NUJS blow me away intellectually. So I think you have to dedicate your resources to helping marginalized populations, getting yourselves involved in public interest litigation, taking cases when there has been a clear injustice against the LGBT rights, working, as I said, pro bono, where there is a need in support of LGBT rights, volunteering for communities, for NGOs if you're not working for one already. So I think that has to take place, where lawyers really need to use their skills to advance the rights of LGBT. And another big part is ensuring access to justice. That is, don't just assist in these questions in Delhi, Mumbai, where there is already a big concentration of lawyers. Think about rural areas, right? Rajasthan, for instance, right? In rural areas where there is a lack of lawyers, or particularly lawyers supporting LGBT rights, right? In Assam, for instance, right? In parts of the country that are more traditional, I think you need to think about, how do we bring access to justice to those communities? Could be through increasingly technology, for instance, cell phones, and helping to provide representation digitally in some way. But I think we need to be creative and not just assist those who are in cities, which oftentimes are the ones that already have access to lawyers. So I think it's, how do we create access to justice in urban areas, but also in rural areas. In terms of internationally, it's difficult. I mean, certainly you can go on to work for the United Nations and be an advocate for for LGBT mainstreaming within the policies and so on. Getting involved, for instance, in Indian diplomacy and being an advocate for the LGBT community, and also looking for international NGOs. Equality campaigns that are involved both domestically, but that are also pushing an international agenda for greater LGBT recognition under international law. So that's what I would say. But again, the key is, in my opinion, in India, access to justice. How do we provide access to justice for the LGBT population, not only in big cities, but also in rural areas? Because that is, again, through India, Africa, through the entire world, it's oftentimes the rural population that is often left out of any of these advances. One other thing I would say is, when we conceptualize our work as lawyers, it's not only about going to court, but it's also about sensitizing, right? That is, giving talks in rural areas about LGBT rights, helping to set up campaigns to advance those rights. And oftentimes, as lawyers, we say, well, that's the role of social workers or advocates. No, it's also the work of lawyers, because at the end of the day, we're campaigning on the basis of rights. Yeah, and we're campaigning on the basis of, these are the rights that these people have. Now we need you, as the rest of the population, to help us support those rights. So I think it's also how we conceptualize our roles as lawyers beyond just being in a courtroom.
And Adam, I just want to correct that this has been telecasted in the YouTube. So students and faculties from all over India are there in this. So not only NUJS students. So
okay.
we are having faculties and students from all over India. Now we have one comment from Nitin Verma and one question. So in this comment, he is saying that in a country like India, where almost all religion looks down on the homosexuals, and where there is not so much taught and talked about homosexuality and LGBT struggles, and he asked a question. His question is that, what according to you can pace the progress of the stigmatization?
Yeah, I mean, it goes along the lines of what I said, is that we have to think about, how do we normalize, right? The idea of LGBT rights and within our communities. And I think all of us can play a role in talking locally with people about LGBT rights, thinking about how we can create campaigns locally about LGBT rights, putting the pressure on the government as well to launch campaigns, equality campaigns, seeing to what extent NGOs want to partner with us, on how do we bring LGBT rights into more rural areas of the country. So I think it's about visibility. Pushing for LGBT, for example, pride parades, for example, I think are important. People oftentimes dismiss it as frivolous, but it's about visibility, right? It's about recognizing this idea of celebrating our sexuality, and particularly amongst groups that have been marginally sort of left on the side. So again, apart from what we can do as lawyers in the courtroom, I think a lot of it has to be teaching about it. I think another thing is introducing it within curriculums at schools. Thinking within a class on civic rights, for instance, and not waiting for university, but starting at primary school. That is when we teach civic rights, well, extending it also to LGBT rights, for instance, talking about that our friends are gays and lesbians. So it's a lot about campaigns and trying to sensitize a population that many of our friends and colleagues are gays, and and look, we love them for who they are. So it's really difficult because you're going up against cultural divide. So unfortunately it's sort of baby steps in a way, but I think we have to, all of us, remain active in pushing for campaigns, sensitization of our friends, stopping people when they use words, right, like faggot, for instance. And I think that all goes to sort of again a broader push within our communities to advance it. But I don't think we can fool ourselves and say that today to tomorrow things are going to be different. I mean, we're talking about years, if not generations, in advancing LGBT rights.
Absolutely, Madam. That if every one of us are sensitized and sensitive towards these behavior, in such situation, things would be in a better place rather than what it is now. And yes, our law enforcement agencies, our judiciary, all the pillars of criminal justice administration has to be sensitized, no doubt. But sensitization among the common citizen has to be there first, and it starts from home, from within us. Yeah, only then actually we can bring a change, see change to it.
Very quickly, you're absolutely right, and I didn't mention that, but police. I mean, police play an integral role, right, in protecting the rights, right, and ensuring that if people are beaten because of their sexuality or whatever, that there is someone held accountable, and that police themselves don't take measures, right, to beat two people holding hands on a street, right. I think you're right that police as well in the criminal justice system has to be severely sensitized to it.
Right. So after that, we are having a couple of appreciation. All of you are appreciating, all are appreciating your talk and finds it very informative and educative. So there's one question from Manisha Chakravarti. In Indian setup, though there is a specific act related to this, that still they are not recognized. Construction has also not recognized them. How to deal with this issue in country like India? Actually, she is using the word constitution.
Okay.
We do have,
yeah.
Yes. No, so we have actually decriminalized this section 377. Irrespective of that, we find that the law enforcement agencies use them. So the legislation has not been amended. So what she's saying that how to deal with the problem when we already have constitutional right to privacy in place by the NUJS judgment.
But how to deal with the problem? In what way? What's
the problem we are having?
It goes to, a lot of it has to come from the top down. I mean, I think the federal government has to, in many cases, take a serious approach to, to providing funding and training police and courts on how to deal with questions involving privacy and sexual orientation. So I think part of it has to come from the federal government. I mean, if we look at the Trump administration now, that hasn't, well, we could see that within American society, for example, there is a real sort of anti-gay discourse that we didn't see so much under the Obama administration, I would argue. So, I think the federal government has an important role to play in speaking out in support of the LGBT community, making even appointments to high positions of people who are LGBT. So I think part of it comes from that. India also has a similar complication, right? Like like the United States, in that it is also a lot of power is given to the individual states within India as well. Again, the governors are they governors? Is that what you would call them of states?
Chief ministers.
Chief ministers, exactly. Sorry, the chief ministers as well have to play a role. The chief judges, for instance, starting with the chief judge of the Indian Supreme Court, but also the judges of the individual high courts within the state have to play a role. So there has to be a policy, a strategic policy, again, coming from the top down in terms of how the federal government, but also the individual states have to play a role in advancing it. So I think the problem is when you have a case like this and then it becomes kind of ad hoc, when there's no real clear strategy in terms of advancing LGBT rights. And I think the government has to take more ownership of that process and think about in each of the different sectors, policing, courts, health, and so on, how are they going to advance an LGBT agenda? And that's something that I think in India, as in many countries around the world, really hasn't taken place. And as such, oftentimes you have good legislation, but the culture continues to be very anti-LGBT. And I think it has to be a state-supported effort.
Okay, thank you, Adam. We have appreciation from our faculties as well. Shampa Singh Karmakar has thanks for your wonderful presentation, put up as a comment. Now, towards the end, I would just sum up in the sense the Indian position little bit. We have now decriminalized our unnatural same-sex relationship by virtue of a precedent. But what happens practically in the field is under the outraging modesty law, that if they indulge, a couple indulge in any kind of behavior, sexual behavior outside the public, then in that case, under the outraging modesty law, the police have power to actually arrest them, and then whatever procedure is there. Now the outraging modesty has been made non-bailable, therefore they would have to be produced before the court to actually get bail, and then proper trial has been taking place. So this is one law where we are having that it has been, the rights which are protected under the Constitution. Supreme Court has already passed a judgment. Irrespective of that, we find that these people are being troubled by the law enforcement agency. Other than that, the society's acceptance is a major problem. And society's orientation is different from the changing times. You will agree with me. And people, even though they are literate or they pose to be literate, but in actual sense, the human rights concerns are not inbuilt among them. Yeah. So in such a situation, what happened? They are highly insensitive towards the behavior they do towards these community, and that leads to a stigmatization of this society in large. Yeah. And we in our country have passed a transgenders protection law for transgenders. In that protection law for transgenders, we have actually made the law very stringent that if anyone violates their right, they would be prosecuted and punished, and all the sections have been made non-bailable. So the law has been very sophisticatedly designed. But when it comes to implementation, we will have to wait and see, because it is just a few months the law has come in. But though there are some gray areas in the Transgenders Act, which is in place in today's time. But we have a community that is the Hijra community, the eunuchs. They are being troubled the most, not only by the law enforcement agency, but also the common people. So, protecting them is the need of the hour in today's time in India. Yeah. So by those few comments, I would thank once again Adam. Yes, Adam.
Actually, it just occurred to me, and this, I think something, if you really want to advance actually the LGBT agenda, I would argue that apart from government, Bollywood. I think Bollywood has the potential to play a huge role here. I mean, thinking about the influence of Bollywood stars, I know 3 major stars just came down with COVID, but I follow on. I'm a big fan of Bollywood. I've been watching, particularly with I've been watching quite a few films. I have a good Indian friend here who always recommends Bollywood films, and I've seen some fantastic ones. But following on Facebook and Twitter. And looking at how Bollywood has evolved, right? Increasingly, it has a more social message, beyond just perhaps aspirations of love, right? It plays an important role. For example, I recently saw Tahani, I think it's called, which means slap, right? Which goes to women's empowerment, for instance. There have been a number of good ones on socioeconomic questions as well. But as far as I know, and you would know more than I do, I haven't seen any on LGBT rights, or maybe they've dealt with it superficially. But I think it's important that Bollywood stars and that Bollywood movies advance it. Right now, I'm actually starting to work on a book on what's called Eurovision, which is the European Song Contest. And one of the big things about this European Song Contest that happens in May is that it advances LGBT rights, right? It creates a visibility. And I think Bollywood actually could play a really important role in putting forward some big Bollywood movies that seek to normalize LGBT rights, because it has the power to extend also into more traditional areas of India beyond the city. So it has an immense power, I think, that should be considered.
Thank you, Adam. Now we move on for the vote of thanks by Aditi Singh. She is also our Society for Advancement of Criminal Justice member. Right, Aditi?
Yes, ma'am. Now, I, Aditi Singh, take this opportunity to thank Dr. Adam Dubin for joining us in these tough and uncertain times and sharing his thoughts with us. Sir discussed the developments and protections granted to the LGBTQ community in Europe and America, which provides valuable insights for India as well to prepare its roadmap. Sir, it was really intriguing how you used pursuant case laws to decipher the concepts and state of affairs. We all are truly privileged to have interacted with you and learned several angles, nuances, and the nitty-gritty of this issue involved in its genesis and existence. Your valuable experience is like a guiding light for us. I hope that each one of us is taking something from what has been a truly enlightening session. I'm sure that this lecture will help legal fraternity at large in the days to come and will provide them with various themes over which academic discourse can be promoted. So, we are extremely honored that you graced us with your presence. I humbly express my gratitude to Kavita ma'am for moderating this session and helping us organize it smoothly. I would also like to thank Honorable Vice Chancellor Sir, faculty members of NUJS, and our faculty advisors, Mr. Fazil Fasih Sir and Mr. Surjakanta Baladhikari Sir, for their constant support. I thank our committee members and all the participants who joined and posed such thought-provoking questions, thereby making this session erudite and successful. Thank you so much.
Thank you very much. Can I say a few words?
Yeah, sure.
So, first of all, let me thank Aditi for that very nice, for those very nice comments. I appreciate you taking the time to do that, and I'm glad that the course was valuable to you. Let me thank especially Professor Kavita Singh, or Kavita Singh Ma'am, as you say in India, who has become over the last few years a good friend. And I think you might, I don't know if you were online when I said this before, Kavita, but I really appreciate you organizing this. And we had a great opportunity to know each other when I was in Calcutta, and your family as well. And I know from speaking, obviously, with many of your students who I've met over the years, just what a wonderful professor you are, and so I appreciate you taking the time to do this, to organize this for us. I also thank NUJS, the Vice Chancellor as well, Dipanshu as well, for helping with the organization of this. And most of all, to all of you, as I said early on, I've just always had wonderful interactions with Indian students, especially here at NUJS, where I had the opportunity to taught. I came into contact with just brilliant students, but across India, I've just been in awe of the sort of not only the analytical ability of students, but your quest for social justice and for making a difference. So whether you are from NUJS or any other university in the world, you are getting an outstanding education in India, and one that is steeped in traditions of social justice, constitutionalism, and I hope that you will take that forward. And if we think about all these cases that we've looked at today, all of these cases have advanced LGBT rights, and in all of these cases, there has been a good lawyer behind those cases, right? We read about it on paper, but we forget there were brilliant lawyers behind them, including in the NAVTEJ judgment. And so I would urge you to take the legal skills that you have, your own brilliance as lawyers, and use it whether you're in the corporate field or in the public interest field, to choose a group of people, whether it be LGBT, whether it be some other marginalized population, and dedicate your time, your pro bono hours to advancing their rights. And little by little, I do think we will achieve advancements for populations that oftentimes, unfortunately, don't always have their own voice to be able to advocate for themselves. And
thank you, Adam. Thank you.
Yes, if anyone has any comments or wants to talk, you have my email address on this presentation, so feel free to email me. You can connect LinkedIn, talk by Zoom or whatever, and I'm happy to talk outside of this session a bit more.
Thank you, sir. It was a privilege for us to host you.
Thank you.
I'm looking forward for more. As I said in the
looking forward to coming to Calcutta.
No, virtually also.
Yeah, once we get this little problem called COVID finished, I will come to Calcutta.
So it has given us many research aspects, many research themes which we can research further.
Yeah. I would love to come, and certainly I would welcome everyone to Madrid. Feel free if you're ever here to email me, and I'd be happy to get together and talk and have a coffee or a meal together. I wish you all very good health during these difficult times. I hope you, your friends, and your family are all well. I think we have to remain optimistic, obviously, that we will all get to see each other again in person, and I have no doubt that we will. Patience.
Everyone has to stay safe and take care of themselves.
Exactly.
Okay,
all right, thank you again, Kavita. Thank you so much, Kavita. I really appreciate it. Take care. Bye-bye, everyone.
We need to thank Mehul also. Mehul was our technical assistant.
Thank you very much.
Okay.
And I just want to quickly say hi to Vanita as well, who
sure. She must be Vanita. Online. She must be online listening to you.
Professor Vanita Prakashino, who was also wonderful to me, and we sometimes talk over WhatsApp. So if you're Vanita, if you're listening, a big hello to you too.
Thank you. If she's not listening, I'll convey your message.
All right. Good to see everyone. Take care. Thanks again for joining.
Bye-bye.
Bye-bye, everyone. Thank you.